Ladies and gentlemen, uh, the years of class 1 or Quranic years are very close relations of the deceased, and on the face of record it also appears that they could have been very important uh, in the life of the deceased. None of these relations except father, true grandfather, in the absence of the son or son, had any right of inheritance in the pre-Islamic rules of inheritance, meaning thereby that the Quranic class consists of 12. Out of 12, before the advent of the Islam, under the customary rule of pre-Islamic Arabia of inheritance, out of 12, only 2 were entitled to inherit the property of the deceased. First and best was the category of son, that is, son or son's son was the first and best person or relation entitled to succeed the entire property of the deceased to the exclusion of all other relations in pre-Islamic Arabian or customary system. If there was no one from the category of the son, there was total absence of this category, and there was father or father's father, then father or father's father was also allowed to succeed the property of the deceased relative before the Islam, pursuant to the customary rules of Arabian society. Rest 8, that is female descendants, daughter or son's daughter, never entitled, never considered as heirs. Therefore, they were totally excluded from the list of the heirs before the advent of the Islam. Likewise, all the collaterals, that is sisterful, sister consanguine, and this uterine class, they all were excluded from the scheme of the inheritance. So out of 12, only 4, not only 4, but in fact only one category, that is category of the Agnetic male descendant class, was entitled before the advent of the Islam. The Holy Quran for the first time recognized 12 relations as class 1 years. And gave them their due hereditary right in the property of their deceased relations. The Holy Quran not only established their right, but also specified their due shares in fraction. The shares fixed for the Quranic class of the years are in fractions, and these fractions are 6 in number, namely 1/2, 1/4, means surviving spouse will be entitled to either 1/2, 1/4 or 1/8. That is, surviving spouse, if it is husband, then he will be entitled to the maximum 1/2 or minimum 1/4. If the surviving spouse is widow, then she will be entitled, or widows, she will be, or they will be entitled to the maximum again, like husband. and the maximum is for the widow class is 1 by 4, or it may be minimum 1 by 8. So 1 by 2, 1 by 4 or 1 by 8 as the case may be. This is the share fixed by the Holy Quran for the spouses, surviving spouse. Then for the daughter class, that is daughter and son's daughter, they are entitled to 2 by 3 or 1 by 3. If the number of the claimants from the daughter class is more than 1, then they will be entitled to 2 by 3 of the net total property of the deceased. If their number is only 1, claimant from the daughter class is only 1, then the claimant of this class will be entitled to the minimum, that is 1 by 2. And this is wrongly mentioned 1 by 3, 1 by 2. And sister class is entitled to that is sister full, sister consanguine. They are considered parallel to the daughter class. Therefore, as daughter class is entitled to the 1 by 2 or 2 by 3, likewise sister class will also be entitled to the 2 by 3 or 1 by 2. It depends upon the number of the claimants. Or now this uterine class, that is brother uterine and sister uterine, together they constitute a class, and this class of the Quranic heirs will be entitled either to minimum or maximum quota of the share. Minimum quota of the share prescribed by the Holy Quran for this uterine class is 1 by 6 and maximum is 1 by 3. When they will be entitled to the maximum or minimum will be explained later on, when their claim will be taken separately. Ladies and gentlemen, this Quranic, out of one thing which is worth noticing about, it is interesting to note that out of total 12 Quranic heirs, 8 are females, only 4 are males, meaning thereby the first and best class of the heirs entitled first in order of priority to inherit is the Quranic heirs. This class consists of the 12 relations. Out of the 12, if one goes to check the list, will find that out of the class 1 total number of the 12 class 1 heirs, 8 are females, means 2/3 are female and only 1/3 are male, means 8 are female and only 4 are male. And more interesting to note is that from class 1, that is Quranic class, which is the first and best class of the heirs under the scheme of Islamic law of inheritance, son is missing, has not been given the status of the class 1 heirs, whereas under all the parallel legal system, son is the class 1 heirs. Rather, he has preference over or they have the preference over rest of the heirs. And even the same was the situation before the advent of the Islam in customary Arabian system. Because in pre-Islamic customary Arabian system of inheritance, son was only entitled to inherit the property of the deceased relative. In his presence, no one was entitled. Entire property was taken by this class. In their absence, again the father class was entitled to succeed. Now, a sweeping reform was effected by the Islamic legal system relating to the inheritance, and the important reform which was introduced or effected by the legal system of the Islam through the Holy Quran was that a separate class of the heirs was created, known as Quranic heirs, and this class of the heirs is the first and best class of the heirs. First, they will be entitled to inherit. After satisfying their claim, if anything left, then other will be entitled. The second thing is that maximum number of the claimants from this class are female, who were not at all entitled, not only entitled, but they were even not recognized as a legal, as a heirs. Or what to speak about being recognized as heirs, even they were not having the status of, proper status of the human being. So, Islam, by conferring the economic right or property right, not only enhanced their social and economic status, but at the same time gave them a sense of superiority, a sense of economic security from cradle to grave. And in fact, Islam made a successful attempt to introduce what is called under all modern legal system, democratic system, concept of gender justice. By introducing the system, this hereditary system, and within the structure of the hereditary system, by creating a separate class, superior class of the heirs, that is the Quranic heirs, class 1 heirs, and by putting within the class 1 heirs maximum number of the females who were not at all entitled to succeed under any circumstance the property of the deceased relative, may be the daughter, may be the son's daughter, may be the mother, may be the sister's class, all of them were absolutely excluded from the scheme of the law of succession. They were brought within the fold of the scheme of succession. Not only they were recognized as heirs, rather they were recognized as a superior class of the heirs, and not only they were recognized superior, their superiority was mentioned by fixing in a fraction for each year of the class 1, and within class 1 year there are 8 females, and in this way this system 1500 years before made the successful attempt to introduce the concept of the gender justice. This is the evidence, conclusive evidence of the fact that Islam made a successful attempt to remove not only gender equalities, but also conferred a respectable status on females by ensuring their economic or property rights in the property of the deceased relative. Now, coming to the next, that is class 2nd heirs, because I have already mentioned that principal class of the heirs is divided into subclasses, and one is known as class 1 Quranic heir. Next to them is another class of the heirs that is known as Agnetic asab or Agnetic heirs. Agnatic, they are known as Agnatic heirs because all of them are agnates. Here agnate means persons related to the deceased directly by blood without any female link in between claimants and the deceased. They are also called as residuaries, or residuary class of the heirs, because they are entitled to take the entire residue, to succeed the entire residue left after specific shares have been provided to the heirs of class 1. Means that in order of priority, first of all, share will be allotted to the class 1 heirs, who are 12 in number. After allocating share to the class 1 heirs of the deceased, whatever property will be left, that property will be called as residue property, and residue will be the claim of the residuary class of the heirs, and therefore class 2nd heirs, that is agnatic heirs, are also known as the residuaries or residuary class of the heirs. They are also called as the customary heirs, because all the male agnates included in this class were recognized as heirs, particularly sons and parents, father. Sons and father, they were even heirs under the customary rules before the advent of the Islam. So, all the male agnates belong to this class. For example, son, son's son, son's son's son, so on and so forth, and likewise all the agnatic male ascendants, that is father, father's father, father's father, so on and so forth. They together constitute as agnatic heirs. They are agnatic relatives, and even before the advent of the Islam, they were entitled to succeed the property in a given circumstance. Therefore, they are also known by another name, that is the customary class of the heirs. 4 female agnates, namely the daughter and son's daughter, sister full and sister consanguine, also inherit as members of agnatic class of the heirs under certain special circumstances. We will explain, I will explain it later on when I will take the claim of daughter class and sister class separately for allocating the heirs, for allocating the shares. Because daughters and sisters primarily are class 1 heirs, because if you go by the list of the class 1, you will find daughter and son's daughter included in the class 1 sharers category. Likewise, full sister and sister consanguine, they are also mentioned in class 1 as heirs. Therefore, basically they are class 1 heirs, but under certain special circumstances, they will be converted into the residuary class and will be entitled to inherit along with other residuaries as the residuary class of the heirs. Therefore, this is also a broader category, that is the agnatic class of the, but remember that this members of this class will be entitled to inherit only when something is left after allotting the share to the class 1 heirs, that is Quranic class of the heirs. Therefore, Quranic class of the heirs are 1 degree superior to the agnatic class of the heirs, that is they are also known as class 2nd heirs. Class 3rd, that is Zabibul Arham, that is they are also known as uterine class of the heirs. To this class belong all the cognates and all females agnates except the 4 who are mentioned who are members of class 1 and class 2, that is daughter and son's daughter, sister full and sister consanguine. It is because of the cognatic connection of the female. Cognate here means persons who are related to the deceased through one or more female link in between the claimant and the deceased. For example, daughter. Suppose H dies leaving behind his daughter, and there is a son's daughter. Now both are agnatic male female descendants, because D is person related to the deceased S directly through blood, and there is no female in between the D and S. She is tracing her relation directly to H. Likewise, son's daughter is also a agnatic male descendant, because she is also connected to the deceased through a son S. Therefore, there is no female link in between the SD and H. Therefore, she is also agnatic female descendant. But suppose there is a H has died leaving behind a DD, that is the daughter's daughter. So D is this D1 is tracing her relation or may trace her relation through the D, who is female, in between her and the deceased. So here between the granddaughter there is a female link D between the deceased and D. Therefore, she will be called as cognatic female descendant. She is the cognate. Likewise, daughter's son. Now here S is claiming her relation to the deceased S through the D. Therefore, here DS is also cognate of the H, but SD is the agnate of the H. D is the agnate of the H. So this is the basic and fundamental difference between agnates and cognates. In class 3rd, that is in the class of uterine class, all the cognates are mentioned as heirs. Ladies and gentlemen, it should also be noted that heirs belonging to uterine class have a rare chance of succeeding the property of the deceased relative. Very remote chance they stand, because first of all the share is to be allotted to the class 1 heirs. After allotting the share to the class 1, if there is someone in the class 2nd, that is agnatic class, then their claim will be satisfied next. Since the class 2nd agnatic class of the heirs, they are also known as the residuary. Therefore, after allotting share to the class 1, whatever will be left, that will be residue, and residue will be taken by the residuary class of the heirs. And once if there is anyone from the residuary class, there will be no chance, zero chance for uterine class to succeed the property in the property of the deceased. Therefore, this class of the heirs is also called as distant kindreds, meaning thereby there is a remote chance of their succeeding out of the property left by the deceased. Now, then another category of the heirs which I mentioned at the initial stage of my discussion, that heirs on the basis of priority to inherit or in order of priority to inherit, heirs of a deceased Muslim are classified into two broader, that is A, principal, and B, subsidiary. Principal classes I have already mentioned. Quranic years, Agnetic years, uterine class of the years. Now, other broader category of the years is under Muslim law recognized under Muslim law is subsidiary class. This class is also classified into following subclasses, namely successor by contract, acknowledged kinsman, universal or sole legatee, government treasury. So, if you look at principal class and subsidiary class, so total number of the relations included in these two broader categories is 7. First three are called as principal class, and rest 4 are called as subsidiary class of the years. Subsidiary class of the years in fact have lost their practical importance and have become nearly obsolete, outdated in modern times. But principal classes of the years are still significant, and normally they stand chance of succeeding or inheriting the property of the deceased in order of the priority. Therefore, discussion on them will be focused, and discussion on this subsidiary class will be ignored because practically there is no possibility for this class of the heirs to inherit in the property of the deceased. Rest I will discuss in my next lecture.